Welcome. This is Holocaust, Genocide, and International Law at Gratz College. I am Professor Kristen Nelson. In this class, together we are going to survey the development of international human rights law through the legacy of the Holocaust to assess whether law can effectively be applied to prosecute the perpetrators of genocide and to prevent genocide in the future. As many of you are assuredly aware, the purpose of the 1948 United Nations Convention on the Prevention and Punishment of the Crime of Genocide, it's a mouthful, so we'll just call it the Genocide Convention in this course, was to punish and prevent the recurrence of genocide after the Holocaust. Since the Genocide Convention's entry into force in 1951, genocide has continued to occur over and over again, and many perpetrators have gone unpunished. At the same time, an entire mechanism of international law has been developed to both prevent genocide and punish its perpetrators. For example, in 1998, the International Criminal Court in The Hague was established as a permanent court with authority to prosecute perpetrators of genocide and other atrocity crimes. But to date, no one has been tried for genocide at the ICC, and genocide has continued to occur. I look forward to having the opportunity to learn more about your interests as we work through this course together. By way of background, I am both a legal practitioner and researcher in the area of international human rights law and Holocaust restitution. I have spent a number of years working on atrocity and asset recovery cases in United States courts that are related to pursuing justice here in the US for Armenian genocide-era crimes and property theft. I was also a lead researcher on a 47-country Holocaust immovable property, or real property in non-legal parlance, study, which examined national property restitution schemes, both historic and ongoing, basically looking into how different countries, mostly within Europe, but sometimes also outside of Europe, work to return, and also sadly in some cases not return, real property like homes, businesses, farms, etc. after the Holocaust. All that is to say is that I hope my background, and undoubtedly your varied and interesting backgrounds, will make for lively and informative forum discussions during the course. Here is the breakdown of today's class. It is going to lay the foundation and provide background for the 7 weeks that follow. We'll go over the course introduction, we'll discuss sources of international law, and we'll finish with looking at the legal history of the Holocaust. Before we get into the brass tacks of how we will be attacking this course, I'd like to pose 3 questions to get us thinking. First question, when you hear or see the words Holocaust and law together, what comes to mind? Do you think of the International Military Tribunal at Nuremberg in the 1940s, as depicted in the photo on the left? Or maybe you think of Israel's trial of Adolf Eichmann in the 1960s, as shown on the right. In this course, I challenge you to think more broadly about law and its relationship to the Holocaust, and to perhaps see it as an event built on legal decisions and laws that first identified and defined a targeted group, the so-called Nuremberg laws being an example. Laws that expropriated the property from people and forced their emigration. Legal directives that sent people to concentration camps and ghettos. And finally, legal directives that covered extermination. In the aftermath of the war, instead of laws being used as weapons of persecution, as was the case under Nazi and Axis rule, law was used to punish and or search for justice at Nuremberg, depending on the state party you talk to. Law was used to void property theft measures, and law was used to access reparations. Second question. When you hear or see the words genocide and law together, what comes to mind? Do you think of Raphael Lemkin, the man who coined the term genocide and doggedly worked his entire life to first see that the international community passed the Genocide Convention, and then later that his adopted country, the United States, would actually ratify it? Do you think of the Genocide Convention itself with its particular and yet very abstract legal definition of what genocide is? Or maybe you associate genocide with the absence of law, because had there been a law, would there be genocide? In this course, I challenge you to again think more broadly, to see where the legal definition of genocide is found in an international convention, in the statutes of international tribunals, in national law, in declarations, to see who can be found guilty of the crime of genocide, to see how difficult it actually is to be found guilty of genocide. The crime requires specific intent, or dolus specialis, and to see how the legal definition of genocide is different from other related atrocity crimes, such as crimes against humanity or ethnic cleansing. Final question. When you hear or see the words international and law together, what comes to mind? Maybe you think of the International Court of Justice, the so-called World Court in The Hague, a photo of which is on the left of the screen. Who appears before the ICJ? States. Maybe you think of the United Nations Criminal Tribunal for the former Yugoslavia, where Ratko Mladic was found guilty of a multitude of offenses by a trial chamber in late 2017, including on charges of genocide in connection with his actions during the Balkan conflicts in the early 1990s. At the ICTY, unlike the ICJ, it's not the state on trial, it's individuals. Maybe when you think of international law, you just think of the UN. Well, it is all those things and really so much more. So I challenge you one more time to think more broadly about international law during this course and its particular relationship to genocide. And think of questions such as the interference in the affairs of another country. When are other countries allowed to or required to intervene, especially when charges of genocide have been levied, as is the case currently in Myanmar? What about non-state entities like ISIS? Are they subject to international law if by definition international law governs relations between states? Can a non-state entity be guilty of genocide? And also, when are states responsible in international law and when are individuals responsible? These are just a few questions we have to go over. We have a lot to cover in this course. So, the logistics of taking Holocaust, genocide, and international law at Gratz College. This is a PhD level class and expectations are high that you keep up with weekly readings and lectures and assignments. A new and distinct topic is covered each week, and so there is little time to catch up if you fall behind. It's important that if, after reading the assigned materials and watching the weekly lecture, you feel you are not understanding the week's topic, to please contact me and set up an office hours appointment. Each week's topic builds on the knowledge of the previous week. Class breakdown. This course is divided into roughly 3 sections. The first is the legal history of the Holocaust and genocide, covered in classes 1 and 2. Next, we'll move on to the legal reckoning with the crimes of the Holocaust in classes 3 to 5, which are divided into international, domestic, and civil processes. And we'll conclude with Holocaust as a catalyst for modern criminal justice in classes 6 to 8, where we will look at modern international criminal law, crimes related to genocide, prevention, and redress. Method of examination. There are 4 types of graded activities for this course. The first is forum participation. Each week, I will post 3 different questions relating to the week's course topic in their own threads in the forum in Moodle. You will have to respond and contribute to 2 of the 3 weekly questions. The second graded activity is host for a week on the course blog. So for weeks 3 through 7 of this course, 2 students each week will be hosts for a week on the course blog. And I encourage you to sign up on Moodle this week for your hosting slot, only 2 students per week. A host is required to prepare a 750-word blog post on a topic of your choosing that is related to the week's lecture. The topic can be current or historic. And it must be different from the one you will be using for your midterm presentation and final paper. The third graded activity is the midterm final paper preview webinar presentation in PowerPoint. At the end of the course, you will be submitting a final paper via Moodle on a topic of your choosing that reveals and analyzes important legal aspects of international human rights law or domestic law as they relate to the Holocaust and/or genocide. But at the midway point of the course, during week 4, you are going to submit a 5 to 10 slide PowerPoint via Moodle and participate in a scheduled webinar to make an oral presentation about your final paper topic using the 5 to 10 slide PowerPoint. You'll sign up via Moodle for one of 2 scheduled webinars, and I urge you to think of the PowerPoint and webinar as an outline for the paper and an opportunity to receive feedback from both myself and possibly other students about your paper topic and sources and other information that may help you complete your final assignment. The final assignment is the 4th graded activity, the final paper. It's based on the topic selected and presented during the midterm final paper preview presentation and must be timely submitted via Moodle. A comprehensive breakdown of the requirements for the graded activities in this course is included in your syllabus, and I encourage you to read it carefully. Finally, I encourage you to remain informed on developments in international law and genocide. For the first half of the course, we're going to be sort of backward looking, taking a deep dive into the history of genocide and how the legal treatment of the crime of genocide was in many ways a product of the Holocaust. But in the second half of the course, we're going to build on that foundation and look carefully at modern international criminal justice, labeling modern atrocity crimes, prevention, redress, things of that nature. Unfortunately, there is a lot going on in the world relating to all of these topics right now. And keeping updated on international events will be helpful for forum responses, blog posts, and final papers. Part 2, Sources of International Law. In a class examining the Holocaust, genocide, and international law, the expectation is that you have a good background in the facts of Holocaust and genocide, if not yet looking at either from a legal perspective. But it's probably helpful at this point to make a brief introduction to international law and how it came about. Let's look at some terminology. You will often hear international law spoken about in the context of public international law or just international law, and then private international law. What is public international law? It's the law of states, states interacting with states. An example of a public international law issue is a disagreement over resources or cultural artifacts. An example of this can be seen in the 1960s ICJ, International Court of Justice, case of the Temple Pre Vihir. In that case, Cambodia complained to the ICJ that Thailand was occupying a piece of its territory surrounding the ruins of Temple Pre Vihir, a place of pilgrimage and worship for Cambodians, and the country asked the court to declare that territorial sovereignty belonged to Cambodia and that Thailand must get out. Thailand objected, and the ICJ found that a French-Siamese treaty from 1904 provided that in the area in question, the frontier line was the watershed, and that a map agreed to by both parties showed the temple on the Cambodian side. Thailand said it never accepted the map, or if it did, it was because of a mistaken belief the temple was on its territory. The court held Thailand had accepted the map and concluded that the temple was on Cambodian territory and that Thailand had to withdraw its troops. So that's states interacting with states. Now, what is private international law? If public international law is a state-state interaction, then private international law, by logical extension, is going to regulate private relationships across national borders, so sort of akin to conflict of laws. What about transnational law? That is all law that regulates actions that transcend national frontiers. This is going to include both public and private international law. For example, in 1998, Spain indicted Chilean General Augusto Pinochet for human rights violations in connection with crimes committed in Chile. But he was then arrested in London and held for 2 years on the principle of universal jurisdiction. So we've got Spain, Chile, UK. And we have a domestic court invoking international law. And that's an example of transnational law. And just for reference, universal jurisdiction means that any state can obtain jurisdiction over a party who commits crimes under customary international law, which we'll go over, the commission of which is generally accepted as an attack on international order. The original crime of universal jurisdiction was piracy and then slavery. Modernly, it's been extended to the so-called, core crimes of international law, including genocide, crimes against humanity, and breaches of the laws of war. We will discuss more about universal jurisdiction and genocide in our next class. What about international relations? That's the interplay of states with each other and with international organizations or interest groups. So this isn't really on a legal level, it's on a more diplomatic and policy level. What about key notions of international law? Natural law is law deduced from natural reason, universal principles independent of man, distinct but sometimes interchangeable with God-made law. Can you think of some natural law rights, such as what Thomas Jefferson put in the Declaration of Independence: life, liberty, the pursuit of happiness, also John Locke? These are sort of Enlightenment, Western, and European concepts. Positive law is the command theory belief where law is backed by the sovereign's threat of a sanction, that law sort of derives its legitimacy from being brought into existence by a supreme legislative power. No sanction, no law. A notable example of natural law in the context of Holocaust studies comes from post-war West Germany. German judges in the Federal Republic of Germany began to apply natural law theories, the sort of God-made law morality concept, and their decisions to alleviate some of the perceived Nazi injustices from the Nazi invocation of positive law. So, for example, in the case of the grudge informer, this was where a woman in 1944 wished to be rid of her husband and denounced him to authorities for insults he had made about Hitler while on leave from the German army. The husband's remarks violated a Nazi-era statute that had outlawed making statements critical of the Third Reich and its leaders. The husband was arrested and sentenced to death, but in the end, he was not executed and was instead sent back to the front and later returned home. In 1949, after the war, the wife was then prosecuted in a West German court, essentially for illegally depriving her husband of his freedom, a crime recognized by the criminal code that was enforced even during the war. The wife said no crime was committed because her husband's imprisonment was in accordance with the Nazi laws, the positive laws. The trial court agreed with the wife, but on appeal, the appeals court said the wife could not rely on Nazi-era statutes, positive law, because the laws were, quote, contrary to the sound conscience and sense of justice of all decent human beings, end quote, and was therefore null and void. So again, the court sort of reaches back and looks at more natural law principles to alleviate some of the damage that had been done by Nazi positive law. So how has international law evolved? From antiquity, let's consider the following example. There are two tribes or groups of people, each one living on a different side of a river. The groups fight each other for hundreds of years, and many people from each group continue to die. One day, a leader from one of the tribes decides to send a warrior of his over to the other side of the river to see if there's something the warrior can do to try to stop the killing. Upon arrival, the other tribe kills the warrior. More years pass, nothing progresses, the groups keep killing each other. Then years later, the leader from one tribe again sends another warrior to the other side of the river to see if an agreement can be reached to stop the killing of people from both tribes. This time, the other chief does not have the warrior killed, but instead they negotiate an agreement to stop the killing. The agreement is unwritten, but the tribes live by it for generations, and in turn, other neighboring tribes begin to live by the agreement made by the first two tribes. This would be considered an early version of the international law term custom that we will discuss shortly. Looking next at Roman law. Roman law has affected the development of law in most of Western civilization and was even part of the law of Germany until the 20th century. we need look no further than the architecture of our Supreme Court to see how Roman affected our country. What is the architecture of the Supreme Court? It's Roman. Roman law has been the basis for the codes of law in most continental European countries, what we call civil law countries. Rome not only developed its own laws based on custom, unwritten law like we discussed, and written laws, but also developed jus gentium, the law of nations, that applied to Romans and foreigners. It was not law from legislators, but law judges applied in cases where foreigners were parties. Then when Rome began to acquire additional territory and provinces, the law of nations would apply. It wasn't until the Peace of Westphalia in 1648 that the first bilateral treaty was signed, an agreement between two parties, written agreement. And then it was until 1814, 1815 at the Congress of Vienna that the first multilateral treaty, an agreement between many parties, was signed. At that point, the goal was to create long-term peace in Europe after the Napoleonic Wars. So basically, heading into the 20th century, there were two types of international law: treaties, written agreements, and custom, unwritten agreements. After World War I, by the Treaty of Versailles, the League of Nations, which is, of course, the precursor to the United Nations, whose mission it was to maintain peace, was formed, but there really wasn't any other international organizations at the time. The Permanent Court of International Justice, the PCIJ, was the first truly international court, and it existed between 1922 and 1946 as a precursor to the ICJ. But in the world before World War II, it was marked by sovereign freedom. There were few rules constraining how governments behaved. There were also really very few general prohibitions on the use of force. In 1928, the US, Britain, France, Germany, and 12 other countries got together in the Kellogg-Briand Pact to condemn war and to renounce it as an instrument of national policy in their relations with one another. But obviously, that did not work in preventing World War II. However, following World War II, the United Nations was to replace the now defunct United Nations, and the UN Charter from 1945 reaffirmed a commitment to peace by all members. The stated objective of the Charter included the development of international law, in particular human rights, the prevention of war, and the promotion of economic and social progress. This was the starting point of a new and more robust form of international law, which shortly thereafter included the passage of the Charter for the Nuremberg Military Tribunal, the Universal Declaration of Human Rights, Genocide Convention, the adoption of the Geneva Conventions, and so on. Treaties covering everything from nuclear testing to the environment were adopted. At some point, even before 9/11, however, the US began turning away from this international law set of rules and agreements outside of an economic framework. For example, the United States did not ratify the Convention on the Rights of the Child or the Rome Statute establishing the ICC in 1998. It was seen as a threat to American power. To the US, the international rules that were sort of established in this post-World War II context were no longer creating opportunity, but they were imposing constraints. To a certain extent, this sentiment continues today and appears to be growing in the conscience of other countries as well. So a question for the future may be whether we want an international order that only deals with economic relationships or whether we want one that promotes other values and interests too, just as the new international order began by doing after World War II. So we've got a basic evolution of international law, but that doesn't answer the basic question of what is international law. In a dispute between France and Turkey at the PCIJ, the Permanent Court of International Justice, in 1927, the court said the following about international law, quote, "International law governs relations between independent states. The rules of law binding upon states therefore emanate from their own free will as expressed in conventions or by usages generally accepted as expressing principles of law and established in order to regulate the relations between these coexisting independent communities or with a view to the achievement of common aims. Restrictions upon the independence of states therefore cannot be presumed. So the court basically said that states were free to do anything not expressly prohibited by international law. This is typically considered the traditional view of international law. There are many other views of international law. They include the New Haven School, socialist, radical feminist theory, mainstream realist, pragmatist. We'll mainly stick with the traditional view, but an example of another view is the mainstream realist pragmatist view, and it goes on that the reality of international law is basically that it works and that we need not go into theories of whether it's accepted as law or not and how or whether it is disobeyed or not. Of this theory, one of the great Polish-British lawyers of the early to mid-20th century, Hirsch Lauterpacht, said judges should basically be responsible for filling the gaps left by norms through the application of general and moral principles of law. The important interpretive role assigned to judges would obviate the need for grand theories of international law. So what are some key features of public international law, both traditional and new? Some of the hallmark features of classic public international law include that there isn't a hierarchy between states. All states are meant to be equal, not one over the other. That sovereign states are will sovereign. That there is reciprocity between states, meaning that the benefits conferred by one state onto another should be granted in kind back to that state by the other state. That they should cooperate. Overlaid on the classical public international law structure of state versus state and this horizontal structure is a system of evolving rules and principles and values and relations between a range of participants in the current world order. Some of these new features include new actors, individuals, NGOs, international organizations, armed groups, terrorist groups. They all now participate and affect the international system. Also, new norms and values. We have an interest in human rights, control and use of force, cyber law, space law. We are reinterpreting rules and values, including sovereign immunity. We have new institutions and new courts like the International Criminal Court and the International Criminal Tribunal for the former Yugoslavia. Now, what is the relationship between the international law that we've been discussing and domestic law? Here's an example. A foreign ship may be captured and the foreign crew tried in a domestic court for, say, ignoring customs laws. The domestic law prescribes a custom enforcement zone of X miles, but the defendant foreign crew argues that international law permits a custom zone of X minus 4 miles and that the ship, when it was captured, had not yet entered into the zone of enforcement justified under international law. So whose law is meant to apply? There are a couple of theories that explain the reception of international law in domestic courts. In monist states, all law is the same. Law is a single entity and it is irrelevant whether international or domestic. There can be only one system of law. In the case of a conflict between international and domestic law, the international law prevails because it is supreme. And in a monist system, treaties don't need to be transformed into domestic law because they already exist. This is also known as the doctrine of incorporation. So in the example, international law would apply and the crew wouldn't be guilty in a monist state. Germany is an example of a monist state. The German constitution says that international law is directly applicable and takes precedent over German domestic law. Now contrast dualist states. In dualist states, international law and domestic law are separate legal systems. Dualism considers international law and national law as independent of each other, and both systems are regarded as mutually exclusive and therefore generally are not able to conflict with each other. They sort of exist side by side within different spheres, the international sphere and the domestic sphere. Meaning treaties in a dualist state are not what we call self-executing and instead require implementing legislation. We call that the doctrine of transformation. Think, for example, the Genocide Convention in the United States. We can't just rely on the convention in the US. we had to have implementing legislation, 18 USC 1091. Also, think about the supremacy clause of our Constitution. Article 4, Clause 2 of the U.S. Constitution establishes that our Constitution and federal laws made pursuant to it and the treaties made under its authority constitute the supreme law of the land. So in a conflict in a domestic court, in a dualist state, domestic law would be applied in preference to international. So in our example of the captured crew, domestic law would apply and the crew would be guilty. Who has the authority to make international law? There is no world legislature. States make international law and not individuals. One of the purposes of the UN since its founding has been the codification of customary international law, so sort of the reducing to writing of international law in an effort to make international law have a more rules-based approach. Now, in order to facilitate that, the UN established in 1947 the International Law Commission, which is composed of 34 international lawyers elected by the General Assembly in their individual capacity, but who are meant to represent the world's legal systems, and they work to codify international law, which is what we call lex lata. So, reduction to agreements and treaties and conventions of what international law is. But they also work on what they hope the law will be in the future, what it's not yet, but what they hope it will be in the future. We call that soft law or lex ferenda. Another important institution with the interpretation of international law is the International Court of Justice, or the ICJ. It was set up in the UN Charter in Chapter 14 as the principal judicial organ of the United Nations. Now, some of the basics of the court include that there are 15 judges elected by the UN General Assembly and the Security Council. They're elected via what we call comity, which is accepted international practice that certain countries are always represented. So, for example, China, France, the US, and the UK always have a seat on the court. Judges have 9-year terms and are re-electable. And in terms of when the ICJ can accept jurisdiction in a dispute, being a member of the UN is not enough. The states have to consent to the court's jurisdiction, and they can do that in a number of ways. So finally, actual sources of international law. Where do we find international law? According to ICJ Statute Article 38, there are 4 main sources of international law, and they include international conventions, custom, general principles of law, and judicial decisions and the teachings of the most highly qualified publicists. We'll take each of those in turn. Treaties. First provision from ICJ Statute 38 on sources of international law. International conventions, whether general or particular, establishing rules expressly recognized by the contesting states. This is basically an old-fashioned way of saying treaties. This is the most specific form of legal obligation between states. Sovereigns enter into these agreements and agree to be bound by their terms. They're like contracts. According to the Vienna Convention on the Law of Treaties, a treaty means an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or 2 or more related instruments. So treaties might also cover documents called conventions, pacts, protocols, charters, covenants, exchanges of notes, and memorandum of understanding. But they only apply to those who are parties to them and are subject to permissible reservations. Reservations mean that when a country ratifies a treaty, it can say, I agree to all of the terms except this particular one. So for example, the Republic of Turkey, when signing on to the Hague Convention on Service Abroad of extrajudicial documents in civil or commercial matters, said, I will not agree to the term which says that you can serve process by mail. Now, Treaties can be in the form of bilateral agreements, so between two countries. They can be multilateral, many countries. They can be a framework agreement, meaning that the big picture is agreed upon in a treaty, and then states develop the more nuanced aspects outside of the treaty. Treaties are gradually replacing customary international law, so reducing to writing what used to be custom. And since 1945, as we discussed, there has been this shift in focus to codify international law through specifically the International Law Commission. Custom. Second provision on sources of international law from ICJ Statute, Article 38. International custom as evidence of a general practice that's accepted as law. Custom is an important part of the international legal system because treaties are a newish construct. There were no bilateral treaties until Westphalia in 1648, as we discussed, and no multilateral treaties until the Congress of Vienna in the mid-1800s. Custom is binding on all states subject to persistent objection, meaning objection from the outset and not waiting until after a state has been bound by custom for many years and decides that it no longer wants to be bound. Customary international law results from a general and consistent practice of states followed by a sense of legal obligation. So we're looking at two elements: general and consistent practice of states, and then followed on a sense of legal obligation, which we call opinio juris. Looking at state practice, you can find that in verbal or physical acts, domestic law, UN General Assembly resolutions, possibly through widespread participation in a treaty, judgments of courts of law, diplomatic acts, and instructions. We're looking at acts that are public and not the private conduct of states. So, for example, testing nuclear weapons, respecting immunity of diplomats. It must be a settled practice. It must be extensive and uniform. The practice must be rooted, but even without extensive passage of time, widespread participation could suffice. Looking at opinio juris, right, the sense of legal obligation. The states must feel like they are conforming to what amounts to legal obligation. An example of custom and customary international law would be prohibition on the use of torture. It doesn't have to be written down in a treaty for it to be prohibited. Looking at the relationship between the first two sources of international law from ICJ Statute Article 38, treaty and custom. Customary international law can apply to a treaty, or a treaty may exclude or deviate from a specific portion of customary international law, but you can't deviate from jus cogens, which we'll discuss in a little bit. You can use customary international law to interpret a treaty if there is not specific language in the treaty indicating how the treaty is meant to be interpreted. Also, treaty rules may become customary and bind states that were not party to the treaty. For example, the Hague Conventions on the Means and Methods of Warfare, which were important in the Nuremberg trials. Some of the involved states were not party to the conventions, but the principles in the treaty became customary international law. So even though you weren't a party to the treaty, you become bound by the principles in the treaty. And a treaty can also crystallize custom and make custom more clear. Looking next at the third provision from ICJ Statute Article 38, the general principles of law recognized by civilized nations. Well, doesn't that sound broad? Where no provision in an international treaty nor any recognized principle of customary international applies, general principles of law can be applied to sort of gap fill. This includes certain principles that you're going to see in all major legal systems, such as more recent law prevails over older law. The notion of res judicata. So, it's already been tried. You can't try the issue a second time. The concept that you can't benefit from your own wrongdoing. An example of general principles used at the ICJ is from the case New Zealand versus France in the 1973 nuclear test. And the court said, One of the basic principles governing the creation and performance of legal obligations, whatever their source, is the principle of good faith. Finally, fourth source of international law from ICJ Statute Article 38. Subject to the provisions of Article 59, judicial decisions and the teachings of the most highly qualified publicists of the various nations as subsidiary means for the determination of rules of law. So here we've got two sources, but they are secondary sources of law. They are not primary sources. We got judicial decisions and the writings of publicists, not writings of people in Hollywood. Judicial decisions. These don't confer precedent, but the rule allows the use of any judicial decision, so from a court, a domestic court or an international court, to be used as a secondary source of international law, which aids the court in looking for sources that identify the law. Similarly, the writings of publicists, which include international law professors, the International Law Association, and you'll look here when there is no judicial decision identifying a rule as custom. So a determination by a distinguished professor carries weight that the law is the way the professor says it is, but it is not actually law, it's simply persuasive. So where does the prohibition against genocide fit into the examination of sources of international law that we've been looking at under Article 38 of the ICJ statutes? The prohibition against genocide is a special case of international law known as a jus cogens, and it's not specifically listed in the statute. Jus cogens are peremptory norms, which are principles of international law so compelling that they override all other sources of international law, imposing obligations erga omnes, which means binding on all. It creates a hierarchy of international law where jus cogens will always trump, and jus cogens will bind states whether they consent to it or not. Article 53 of the Vienna Convention on the Law of Treaties describes a peremptory norm of general international law as a norm accepted and recognized by the international community of states as a whole, as a norm from which no derogation is permitted, and which can be modified only by a subsequent norm of general international law having the same character. The International Law Commission's commentary makes it clear that by the phrase derogation, it's meant that no agreement can be made to contract out of those general rules of international law. An example would be that one state is allowed to contract with another state to stop and search its ships on the high seas. But any agreement with that same neighboring state to carry out a joint operation against a racial group straddling the frontier, which would constitute genocide if it were carried out, is void since the prohibition with which the treaty conflicts is a rule of jus cogens. ICJ case law has identified jus cogens as including the prohibition against genocide, self-determination, rules outlawing aggression, rules protecting the human person, such as racial discrimination, and rules against slavery. And finally, how do jus cogens relate to the sources of international law from Article 38 of the ICJ statute? Some say it is a manifestation of super strong custom, while others describe it as manifesting general principles of law. Before we move on to the final part of today's class, let's recap for a moment some of the information we've learned in sources of international law. It's included terminology, differentiating public international law, private international law, transnational law, natural law, and positive law. We've looked at how international law has evolved from antiquity through World War II into today and how it's continuing to evolve. How international law is incorporated into domestic law. Is it a monostate? Is it a dualist state? It does matter. We've looked at sources of international law from treaty to custom to general principles to secondary sources such as judicial decisions and writings of publicists, and on to the most important type of international law for this course, arguably jus cogens, norms from which no state is permitted to derogate. All of these concepts are laying a foundation to help us in future classes be able to understand particular crimes that are prosecuted at Nuremberg, how the Genocide Convention and its particular language came into being, how the convention's been incorporated into different domestic laws around the world, and how mechanisms for prosecution of genocide have been able to come into being. In this last part of today's class, we're going to look at the Holocaust through a legal lens. Think about how the period between 1933 and 1945 could be looked at as a series of legal events that gradually changed the status of Jews from citizens to non-citizens to something less than human and not worthy of life. We'll look briefly at the stark contrast between the legal system in the Weimar Republic and then what transpired under the Third Reich. And then we'll look at the 4 stages of the war against Jews, which can be classified and divided into identification and definition, expropriation and emigration, concentration and ghettoization, and finally extermination and annihilation. The pre-World War II Weimar Republic was a fractious, multi-party parliamentary democracy in Germany between 1919 and 1933. Its laws and jurisprudence were looked upon as inspiration prior to World War II in many other jurisdictions because the Weimar Republic was characterized by independent judges. It was a law-based state. There was a constitution that protected individual rights. However, one of the key features was legal positivism, which, as we've discussed, are rules that are passed and kind of backed up by threat or sanction or threat of force by the government. And this becomes important when the Nazis come to power because they sort of co-opt this favoritism towards legal positivism, and they make sure that their persecution of Jews, of other undesirable groups, of the Roma, of disabled individuals are based on legal decrees. And without the legal decree, they don't believe there is this legal cover to persecute. And, an example that sort of demonstrates this is when Hermann Goering suggested that German travelers can always kick off Jewish passengers in a crowded train. And the propaganda minister, Joseph Goebbels, says, well, I would not say that. I don't believe this. There has to be a law. So there was this notion, unless there's a law, you can't persecute anybody. You can persecute people pursuant to a law. Now, going back to the sort of fractious nature of the Weimar Republic, the National Socialist German Workers' Party, also known as the Nazi Party, was one of the many political parties in this fractious Weimar Republic. And the party blamed Jews inside and outside of Germany for the country's defeat in World War II. In 1933, the Weimar Republic came to a crashing conclusion and was replaced by the Third Reich. On January 30th, 1933, Hitler, as the leader of the Nazi Party, became Chancellor of the Weimar Republic after his party had won the most seats in a November 1932 parliamentary election. The goal for 1933 for the Nazi Party was to eliminate its opposition, and it was done through a number of legal measures. The first step toward establishing a single-party dictatorship was the Reichstag Fire Decree. The Reichstag Fire occurred in February 1933, leading to the Reichstag Fire Decree under Article 48 of the Weimar Constitution, which allowed the president to rule by emergency decrees under certain circumstances without prior consent of parliament. The next step in establishing a single-party dictatorship was the Enabling Act in March 1933. This was the law for removing the distress of the people and the Reich. A seemingly innocuously named law actually gave Hitler the authority to rule by decree for 4 years. And so with this, we have reversion to a dictatorial regime instead of a parliamentary government. In July of the same year, the law against the formation of parties was passed. So no longer could any new political parties opposing the Nazi Party be formed. And all the while, Dachau had been opened and political opponents were being stuffed inside. In 1934, President von Hindenburg died, and Hitler combined the roles of president and chancellor in himself, meaning that all laws, including the Constitution, became subsumed under the so-called Führer principle. law was replaced by decisions of Hitler. And at the end of the Weimar Republic and the beginning of the Third Reich, we divide the 12-year Third Reich period into two smaller periods. We have 1933 to 1939, which is noted by Hitler's consolidation of power in Germany, the annexation of Austria, and takeover of part of Czechoslovakia. And then 1939 to 45 is characterized by the German invasion of Poland, UK and France declare war on Germany, and World War II begins. Stage 1 of the war against Jews, identification and definition. Persecution of Jews began with anti-Jewish laws past the National Socialist era, and the laws were gradually used to change the status of Jews. The laws were big and they were small. For example, the 1933 law for the reestablishment of the professional civil service banned Jews from the civil service. A 1933 Baden State decree banned Yiddish in cattle markets, and there was even a law banning Jewish use of Aryan hairdressers. No matter was too small to legislate. In 1935, the so-called Nuremberg laws were passed. They were two laws, the Reich Citizenship Law, which deprived Jews of citizenship, and then the Law for the Protection of German Blood and Honor, which forbid marriage and extramarital sexual intercourse between Jews and citizens of German or kindred blood. The Nazis had defined Jews by genealogy and not religion, which means you didn't have to practice Judaism to be considered a Jew. And so the Nazis then had to make up more laws to define who was a Jew. Stage 2 of the war against Jews was characterized by legal and extra-legal expropriation of property and emigration between 1935 and 1939. For example, in 1937, as coercion to emigrate, persons were promised to be freed from Dachau if they left the country. In November 1939, in response to Kristallnacht, a night 1,000 synagogues were burned and over 7,500 shops looted, the government issued a decree fining the German Jewish community 1 billion Reichsmarks and issued another decree ordering German insurance companies to pay the state and not Jewish owners for their losses. Historian Peter Hayes, in a discussion aptly titled Learning How to Steal Germany between 1933 and 1939, aptly summarizes the state-sponsored robbery in his book, The Oxford Handbook of Holocaust Studies, and I wish to share just a few short passages with you so that we all may get a better visual sense of what the level of stealing was like during this period. By the end of 1937, 60% of the roughly 100,000 Jewish-owned businesses in Germany as of 1933 had been liquidated or Aryanized. The total wealth of German Jews had fallen by 40 to 50%. 1/3 of the German Jewish population had fled the country, and nearly all of the Jews remaining were working for themselves or each other or unemployed and dependent on the community's relief measures. Kristallnacht accelerated the robbery. Following the Kristallnacht pogrom of November 1938, this system of dispossession was extended to the entire Reich and expanded in a variety of ways. All German Jews had to establish blocked accounts. The Aryanization of all Jewish-owned businesses became compulsory at terms set by politically appointed trustees, and a fine of 1 billion Reichsmarks was imposed on the Jewish population. Each person who had registered his or her property in the summer of 1938 now had to pay 25% of its total value in installments to the National Treasury by August 1939. Doing so became doubly difficult when the regime ordered Jews to put their stocks and bonds in safe deposit accounts from which sales could take place only with government permission, and forced Jews to surrender virtually all their possessions containing precious metals to the state-run pawn shops in return for nominal compensation paid to blocked accounts. Such restrictions compelled Jews to convert as many of their other assets as possible to cash, often by selling their furniture, artworks, and household goods, and by redeeming their insurance policies for their paid-in value, which went directly to the blocked accounts. On the eve of World War II, the robbery was complete. By the summer of 1939, the Third Reich had reduced German Jews to penury and pocketed at least 3 billion of the 7.1 billion Reichmarks in property that they had registered the previous year. In the succeeding years, the regime may have raked in as much as half of the remainder through additional impositions, the mandatory conversion of sums in blocked accounts into war bonds, and the terms of the 11th decree to the Reich citizenship law, which declared that the property of German Jews, quote, fell to the state as of the moment they exited the country, whether through emigration or deportation. Stage 3 of the war against Jews was characterized by concentration and ghettoization between 1939 and 1941. In September 1939, war broke out, and as Hitler invaded Poland, France, Belgium, the Netherlands, Norway, Denmark, Greece, the Reich's Ministry of Justice was recruited to develop laws to apply to these territories formally and informally incorporated into the Third Reich. Multiple types of laws were required for conquered and occupied regions. There was governing law for areas annexed directly into the German state, such as Austria. German law applied. For areas under direct German occupation and direct administration, such as the general government of Poland, occupation law applied. As an occupier, Germany could make new rules and laws in Germany to be applied in Poland, and that was technically in conformance with the international law on occupation. Finally, for puppet regimes such as Vichy France, laws were passed by those new regimes in France, but they were heavily influenced by Germany. There were also laws applying to resistors. In 1941, the Night and Fog Decree was passed. The laws were used to deal with resistance of local populations and authorized extraordinary measures in all occupied territories. Political suspects were disappeared. Summary court proceedings preceded either killings or imprisonments, and the laws were justified as being necessary to protect German troops from terrorist acts. There were also so-called atonement measures, collective punishment for attacks on Germans or German property, and that meant that innocent people from communities where crimes were committed were shot. Finally, there were laws for concentration into ghettos. By decree, Jews were concentrated into ghettos on grounds and reasoning such as health and safety, and then Jewish councils were forced to transmit German directives to the Jewish population, and Jewish police were used to enforce Germany's discriminatory laws. Now, Raphael Lemkin's 1944 Axis in Occupied Europe book compiled a list of these laws that were being used across Europe to persecute populations. His study showed that Nazi laws had turned European jurisprudence on its head. The laws did the opposite of protecting the population. The laws were persecuting them. The fourth stage of the war against Jews was characterized by extermination and annihilation between 1941 and 1945. There was a state-sponsored plan to murder all Jews between that time period under the cover of legality, and it began with Germany's invasion of the Soviet Union in 1941. In May of that year, Barbarossa Jurisdiction Order and Commissar Order was issued, and it provided legal cover for partisan killings by German troops. The order suspended courts-martial for civilians suspected of sabotage or guerrilla warfare and allowed and encouraged the summary killing of these individuals. Conveniently, no definition for commissar in the order was provided, so by law, Jews posing no resistance to fighting military became subject of fair-game mass shooting. In September of that same year, the hostage reprisal order was issued, and it called for the killing of 50 to 100 undefined communists for every German life lost to insurrection in occupied territories. Now, we have to dispel the notion that only uneducated people were partaking in this mass killing. In fact, it was quite the opposite. Einsatzgruppe and the Special Action Murder Squads rounded up Jews and other targeted groups, Roma, political dissidents, disabled persons, Jehovah's Witnesses, and murdered them by firing squad and mobile gas killing vans to the order of 1.4 million individuals. Tellingly, the majority of Einsatzgruppen generals that went on trial at Nuremberg after the war were not uneducated individuals, they were lawyers. Directives were also passed promising death to anyone who assisted Jews during this time period. For example, in 1942, there was a Warsaw Directive promising capital punishment to both Jews found to have left the ghetto and the persons harboring them. The policy of extermination originated in Germany and was implemented through secret orders beginning in 1941. Reichsmarshal Hermann Goering issued a secret directive to Reinhard Heydrich, head of the Reich Security Office, stating, "I hereby charge you with making all necessary preparation in regard to organizational and financial matters for bringing about the total solution of the Jewish question in the German sphere of influence in Europe. Where other governmental agencies are involved, these are to cooperate with you. I charge you furthermore to send me, before long, an overall plan concentrating the organizational, factual, and material measures necessary for the accomplishment of the desired solution to the Jewish question." This directive was put into state policy at the Wannsee Conference in January 1942, where participants were informed of a plan to murder the 11 million Jews of Europe. Of the 15 participants at this conference, 7 had law degrees. Unlike the raft of previously passed legislation and laws that stripped Jews of their civil rights, the extermination policy was never published in a formal law gazette. Secrecy was meant to lull victims into believing they were being resettled to the east, and the killings continued even when the tide of war had turned on Germany. Yet at the end of this first class, I leave you with the following. At the very end of the war, the justification made for the extermination was that it was legal. Was the extermination program legal? Konrad Morgan was an SS judge given the mandate to prosecute crimes by SS personnel in concentration camps, and he dedicatedly pursued corruption and unauthorized killings at the camps. But when it came to mass extermination at Auschwitz, he said he was powerless. He said, quote, "I saw that those killings, by being ordered, were legal in the sense of National Socialist law, and therefore I could not take any direct action on this sector."